Hey, everybody. It seems like forever since I've been here. Welcome. For those of you who might be new, I'm Lori Hellis. I'm a retired criminal defense attorney and writing a book about the Vallow Daybell case. And when we're here on True Crime Wednesdays, we talk about all things true crime. And I was not here last week, so we have so much to talk about. It's amazing what happens in just an extra week. So, hello. I'm gonna just vamp a little bit while we let chat catch up. But I did want to let you know what was going on with me last week. So, for about the last 6 or 7 years, I have been the legal guardian and conservator of my aunt. And I took over as her guardian because she developed dementia. And my poor little mom, whose younger sister she was, wasn't really able to step in and make arrangements and make decisions for her. So she's been in a memory care facility for, like I say, probably 7 years. And last week, they'd let me know that they had moved her onto hospice and she was receiving hospice care. But she'd been in a slow decline for quite a while, and it had been several months that she'd been on hospice when they let me know that she was failing pretty quickly. I'm super grateful that her son, who has been fairly estranged from her and lives in another part of the country, was able at the last minute to fly in. He spent a couple of days with her. He was with her when she passed on Saturday night. So, but because I was her guardian, I had to drive over to Bend, which is about 6 hours from Boise, in order to help make all of her final arrangements. So I didn't get back to Boise until Tuesday night. And by Wednesday, I was just whooped. Most of you know I had hip replacement surgery 5 weeks ago on Wednesday. And so that Wednesday, I was pretty much just still whooped. So thank you for all your good wishes. She was my mother's youngest sister. She was 78, and which is young, and was really young for her to develop such serious dementia. My family doesn't have a history of it. She really is the only one. So, but she was the fun aunt when I was growing up, the rock and roll aunt, because she was the youngest. So just thanks for all your good wishes. I'm super grateful that her son was able to be with her. It was really important both for her and for him. And so I'm really glad that we were able to make that happen. You might remember at our last live, I was a little distracted toward the end because I was in the midst of him making the decision to come and trying to help him make travel arrangements and get them all here. And fortunately, he arrived on Friday night and was able to spend all day Saturday with her. And so I'm really grateful for that. My mom is doing great. Lots of people asked because they were worried that if it was something family going on, it had to do with my mom, who lives in an assisted living just a few minutes away from me here in Meridian. She's doing great. She's about to turn 90 next month, and or actually in a couple months, and she's doing great. So thanks everyone for asking. Most importantly, thank you y'all for caring. My hip replacement has been remarkable. My physical therapist keeps just shaking his head and can't believe how well I'm doing and how quickly I've recovered. So that's all going really great. I'm hoping once I hit the 6-week mark to be moving out of physical therapy. And oh my goodness, sounds like the UPS guy is here. My dogs are letting everybody know. So I just appreciate that we are such a great community and that we care about one another. And I thank you that you guys care about me. We have a bunch of stuff to talk about. First of all, I want to remind everybody that Monday will be Lori Vallow's sentencing. Now, we're expecting that it's going to take the better part of the day on Monday, but that it will be finished on Monday. The court is live streaming it from the court's website. And also, I know that there are quite a few different platforms that are streaming it. I know that Nate Eaton from East Idaho News will be streaming, along with, I'm sure, other platforms. It will be on the judge's YouTube channel directly for those who want to watch it directly. There was a hearing this morning. It's been a long couple of days. I've been trying to catch up on all of these cases. And during that hearing, Judge Boyce did decide that Vicki Hoban, who is Tammy Daybell's aunt, she is Tammy Daybell's mother's sister, will be allowed to make a statement as a representative of the victim of Tammy. The judge found that there's nothing in the statute that says that only one person can be designated as a representative for a murdered person's family or for the murdered person. And so that was welcome. That was wonderful that Tammy's family are going to have a voice in all of this. My understanding is that Tammy's father, as well as her sister, will also be, entering a statement or reading a statement. The judge noted that there have been people who have submitted as a part of the pre-sentence investigation, and that they won't necessarily be reading a statement or making a public statement, but that their input was considered in the pre-sentence report. So it was interesting. The judge did make a couple of points that I thought were worth noting. One is that I know that there are a lot of people who have expressed the opinion that this seems unfair, and that in other jurisdictions it is permitted for as many people as want to make statements. This judge and Idaho Supreme Court law makes it clear that the statute is the four corners of what can be allowed. And the judge made this point, which I thought was worth talking about. And that's that victim statements are unusual because they come in without there being they don't take an oath to tell the truth, and there's no opportunity for cross-examination. So there's really no way for either side to challenge information that might come in a victim's statement. In the state of Idaho, there is concern about that, and the judge did make that point, and that in Idaho, it is thought that limiting the number of people who can make statements to people who are directly impacted by the defendant's crime lessens the possibility that those statements are going to in some way influence the finder of fact. Now, the judge did also recognize that when the judge is the finder of fact, there's less opportunity for that because the judge is more schooled in being able to sort out what's relevant from what is irrelevant. that is part of a judge's job, where it is possible, if the jury is making the decision in a capital case, where the jury could be influenced unduly by victim statements. So that all made sense to me. I understand that people have expressed their concern about victims not being heard, but I do think that the primary victims in the case, those who are directly impacted by the murders, are going to have a voice and are going to be heard, both by the public, because it's going to be live streamed, and by the judge who will be making a decision. So we expect that Lori is going to be sentenced on Monday. We expect it is going to be a life sentence. The only question is whether it will be with or without some possibility of parole. We've discussed before that the state of Idaho is an indeterminate sentencing scheme, meaning that the judge has more discretion than indeterminate sentencing schemes such as Arizona and my home state of Oregon. So that's going to be super interesting. Look for that to happen on Monday. I expect that you'll hear from me on Monday. I haven't cleared that with Michelle yet, but I think we will try at least do a short live to talk about the outcome. So look for that on Monday. And there have been so many other developments in other cases that you all are interested in that I'm prepared to kind of run through the gamut. And once we've had a chance for me to sort of give you a few recaps and my thoughts on them, then we'll take some questions about whatever it is that you all want to talk about. So first of all, a lot of you were watching the YNW Melly trial. This is a Florida trial by an African-American rapper, kind of an up-and-coming young rapper, who's accused of murdering two of his good friends and bandmates. That trial went on for several weeks. The court took a week break and came back. And then when it went to the jury could not reach a decision. And after two attempts to try and get the jury to go back and deliberate, the judge declared a mistrial, because a hung jury is one of the bases for a mistrial. So now the prosecutor is going to have to retry the case. Hung juries and being able to retry a case is not always a bad thing, because the prosecution has really had an opportunity to sort of look at what worked and what didn't in their case. They will have some opportunity, I believe. States vary, but I believe in Florida they will have some opportunity to ask questions of the hung jury. And so as they move forward, the prosecution needs to decide whether or not they're going to retry the case. Presumably, they are going to retry a murder case. Upon occasion, in cases where that are not quite so serious, sometimes prosecutors decide it's not worth it to try and retry the case. The next case I want to talk about is Taylor Shabusiness. This is a horrendous case. It is out of Wisconsin, and it is a two-phase trial. The initial guilt or innocence phase wrapped up today with a guilty verdict, and then the second phase will be the guilty but insane, or guilty by reason of mental disease or defect portion of the case. She pled not guilty, and then in the alternative, not guilty by reason of mental disease or defect. So there's some interesting little wrinkles to this. this is the trial. It is so grisly. I hesitate to go too far in depth on it, other than to say that her victim, Shad, was an old high school friend. They had at some point dated. They were in his mother's basement using methamphetamine. She admitted to strangling him. And then she also admitted that she didn't know what to do with his body, and so decided that dismembering him was the way to be able to remove the body and to hide it. His mother came downstairs after she heard what turned out to be Taylor leaving and driving away, and discovered his severed head in a bucket at the bottom of the stairs. It's a horrible case. It is a parent's worst nightmare. It is a question. There are many questions, a lot of them having to do with their use of methamphetamine. She admitted that they had been smoking methamphetamine and believed that that contributed to what happened afterwards. However, we've had this conversation before. Voluntary use of a mind-altering substance is not a basis for an insanity defense. If you voluntarily are intoxicated to the point where you do not understand the gravity of what you are doing, or are not able to determine right or wrong, you voluntarily decided to use that substance. And it has always been the state of the law that voluntary intoxication is not a defense, and is not does not qualify as a mental disease or defect. So, but there is a place for a mental disease or defect when it comes to chronic use of methamphetamine. It is well known that the use of drugs, and methamphetamine in particular, does alter the physical qualities of your brain. It does cause damage to the physical structures of the brain. And if it can be proven that the physical organic structure of her brain was damaged to the point where she did not understand the gravity of her actions, it doesn't necessarily matter how that damage happened, whether it was accident, injury, drug use. So it will be interesting to see in the NGR, not guilty by reason of insanity or mental disease or defect, as they call it now. It will be interesting to see what experts are put on, and how they present that information. So it's important to know, though, that if you are trying to make that argument, you need to have experts who can back that up. Typically, those experts are going to be not only forensic psychologists, but a forensic neuropsychologist. And a neuropsychologist is one who is going to be able to administer the sort of tests that show whether or not this person has actual physical brain damage, or that there is some other sort of injury or disease to the brain that causes them to have a mental disease or defect. There was a short hearing after the guilty verdict was brought, in which the judge discussed the qualifications of a couple of the defense experts, and whether or not there was a basis for that expert to make a finding and to express their opinion. It's going to be interesting to see whether or not that particular expert, there were two experts that the judge wanted to talk about. The first one is a pharmacologist. And the argument from the defense was that she was an untreated, that she had untreated bipolar disorder, and that contributed to both her use of and abuse of methamphetamine, as well as her actions and the way that she reacted to the methamphetamine. So it's going to be interesting to see whether or not the judge sort of buys that argument and allows that expert to come in and testify as a pharmacologist about the impact of methamphetamine on an untreated, a person with untreated bipolar disorder. We'll have to wait and see what happens. The other interesting little twist is that in Wisconsin, 5/6 of the jury have to find that she is not guilty by reason of insanity. It doesn't have to be unanimous, which is kind of interesting. One of those gee whiz moments. I guess you have to be a lawyer and want to get down in the weeds, but it was kind of interesting. One of the huge things that's happened since the last time we visited is the Long Island serial killer arrest. A gentleman whose name is Rex Heuermann was arrested after a year-long investigation following a tip about a vehicle similar to his being in the area at the time of one of the murders. Now, I'm sure that you all have been following it because it's been in the news everywhere. But if you've been under a rock, the Long Island serial killer, the first bodies were discovered in 2010, and they have continued to search for this person. There were 4 young women. They were all sex workers. They were all their bodies were all disposed of in similar fashion, wrapped in duck blind camouflage burlap, and their bodies were left on Gilgo Beach on Long Island. And Mr. Heuermann lives 20 minutes away in a home that he has lived in his entire life. He grew up in that home and then inherited it from his mother. And he was an architect working in Manhattan. He also is huge. He's got to be at least 6'4", could be much taller than that. And many people have described him as ogre-like. So really interesting case. Interesting how the investigation unfolded. They were able to use some familial DNA, which was significant. They were able to match a hair that was found on one of the murdered women to him, but 2 hairs on the women that had belonged to his wife. There's been a lot of speculation about whether or not these women could potentially have been killed in his home. The disappearances happened during time periods when his wife and his children were away or out of town, and in some cases out of the country. So then they are also looking at his travels. He traveled to conferences and owned a timeshare in Las Vegas, and also owns property in South Carolina where his brother lives. It's pretty evident from both properties that he was something of a hoarder. The house was very cluttered. The property in South Carolina is littered with junk. And so it will be really interesting as that unfolds. He has been charged with 3 of the 4 murders. He has been charged with murder in the deaths of 3 of the 4 women who were found. The 4th, they're expecting to charge him, but are still waiting for lab and DNA results. Spit it out. Lab and DNA results in that case. And they said that the DNA in that particular case was somewhat degraded and was a little bit more difficult for them to make matches. So it will be really interesting to see. This is yet another case where advances in DNA have led to identification of a suspect, including them snagging pizza and swabbing pizza crusts left over when he threw them in the trash outside his office. A lot of you asked me about this Sarah Boone case. Sarah Boone is the woman who is being held for murder after zipping her longtime boyfriend into a suitcase and leaving him there. It's a very disturbing case because the video that is out there, she initially said they'd both been drinking, they were kind of playing this game, she zipped him into the suitcase and then kind of passed out and didn't realize that she had accidentally left him in the suitcase until the next morning when she unzipped him and he was dead. That is belied a little bit by the fact that there were recordings recovered off of her telephone where he's in the suitcase. You can hear him calling her name, talking to her. You can see the suitcase moving, you know he's in there. And she just keeps saying, this is what you get. This is what you get for strangling me, suffocating me. So sorry you can't breathe. And kind of taunting him, which sort of negates the idea that this was an accident. This case is also interesting because Sarah Boone has sent many, many letters that have been released to the public, to the judge, to her lawyers, to the public defense board, I think. And she has been trying very hard to get some response out of her lawyers. She had a lawyer for somewhere around 2 years that was retained, and that lawyer withdrew. She was appointed a lawyer, and just to sort of back up and sort of give you all a little bit of background, because this question comes up. When you're a public defender, you basically are on a rotation on call. And so you or your organization gets a call. For example, I belong to a consortium of attorneys that had a contract with the state. And so what would happen is our administrator would get a phone call from the court and the judge would say, we're appointing your group to this case. Or a judge would say, we're appointing this lawyer from your group to this case. So the next thing that would happen is then that both the administrator and the individual lawyer would do a conflicts check to find out whether or not the lawyer had previously represented anybody involved in the case, particularly previously represented a victim or a co-defendant. Now, Sarah Boone doesn't have any co-defendants, but her victim did have a fairly lengthy criminal history from what I understand. And so the second, third, and fourth lawyers that were appointed to represent her all had to withdraw because they had conflicts, because they had previously been involved in cases with the victim, the decedent. So one lawyer that was appointed was leaving the public defender in order to become a law professor, and so that lawyer had to withdraw as well. And finally, lawyer number 6 comes on. Now, for most people, you hear somebody's had 6 lawyers and you think, holy cow, this person is somebody that nobody can work with. And it is always true that you don't want to be the 3rd lawyer on a case, or the 4th, or the 5th, or the 6th, because that indicates that your client is someone who nobody can work with. I'm not sure that's the case here, because lawyers, the first lawyer withdrew, likely because he was retained and she couldn't pay him anymore. And then 2, 3, 4, and 5 had to withdraw either because of a conflict or because of unavailability. So lawyer number 6 comes on the scene, and Sarah Boone has been asking the judge repeatedly for contact with her attorney, and has been complaining repeatedly that her attorney is not being responsive and is not contacting her. Now, we don't know how much of this is accurate, but it does appear that her appointed lawyer should be responding to these requests for her to communicate, for Sarah to be able to communicate with the lawyer. So it's understandable that she's concerned. She's also been concerned because there have been pretrial conferences that she was not present for, even though the rules say that she should be able to be present for any hearing. So her case has once again been continued. As far as I know, it has not yet been reset. But it is an interesting case because, like the Schabusiness case, there appears to be some pretty damning information in the record right out of the defendant's mouth. In the Schabusiness case, it was her getting a case of verbal diarrhea and telling the police everything. And in the Boone case, it was the result of these videos on her phone where she can be heard in her own voice telling her victim all the reasons why he should be left in the suitcase to suffocate. So that one's going to be interesting. We do get a trial date for that one. Now, Kohberger, University of Idaho murders. There have been a couple of filings recently that have happened and that people have lots of questions about. And we'll get into these filings as a little bit more time goes on and we see where they go. But 2 of them recently, one was at least a suggestion in a filing that the defense was claiming or suggesting that the DNA that was found on the knife sheath was planted. Now, logically, it doesn't make a whole lot of sense. Why would the police plant DNA of a completely unknown person on a sheath? There have been some discussions about, how it could be possible, but honestly, it doesn't necessarily make a tremendous amount of sense. A lot of people liken it to O.J. Simpson and the allegations that Mark Furman planted DNA evidence, planted O.J. Simpson's DNA. The difference is that in the O.J. case, the DNA, they had already drawn O.J.'s blood, and the DNA was available to law enforcement in a way that could have been planted. So that is a little curious. I'm not really sure we get deeply into DNA being planted. The the defense did also point out that there were at least 2 other male DNA depositors whose DNA was found in the house, and a third DNA profile that was not any of those 2 or Kohberger that was found on a glove outside the house. So let's remember, first of all, the house where these murders occurred was a party house. The fact that they only found DNA from 2 unknown men is probably the most surprising part, because frankly, there were a lot of young men in and out of that house. Second, it was winter time. And so it isn't at all surprising that somebody might accidentally drop a glove outside. All you have to do is walk down any street or any downtown area where it's winter, and you can see people have dropped their gloves. You see it in Boise, Idaho. I'm sure you see it in Moscow, Idaho, and I'm certain that you see it in a lot of other places, especially on college campuses or around schools. So I don't find that particularly surprising either. But the defense does have a right to know whether or not those DNA profiles have been identified, and if so, who they've been identified to. Now, one of the things the defense has been attempting to get, and which I don't think they're going to get, are the family trees that were actually created by the investigators doing the familial genetic investigations. So the genetic genealogy that was being done. A genetic genealogy really is tracking back, trying to find a common ancestor for the depositor. And they do that using a couple of genetic databases. They are not the 23andMe and Ancestry databases, because they have a pretty ironclad contract with their users not to share their information with law enforcement. If you have a genetic profile on file with Ancestry or with 23andMe, you can upload your results from either one of those services to one of the services that is available to law enforcement. But it isn't, that doesn't happen unless you do something to make that happen. So the defense has been trying to get those family trees and to get sort of the basis of the genealogical DNA investigation. And to this point, the prosecution has been resisting and has asked the court for a decision about whether or not that information has to be released. I suspect that the court is not going to require that to be released any more than they would require that the raw computational data accompanying a DNA finding would have to be released. Now, in some states, the defense does have the right to have the law enforcement lab share that information with their expert. And in some states, they do have the right to request retesting by an independent lab. So in the Vallow case, we had the situation where we had DNA that was going to be consumed by the testing. So everyone got on board and agreed that that raw data could be shared with the defense experts. That is not something that always happens unless everybody agrees to it or a judge orders it. So in this case, I don't think they're going to get that information, particularly because Remember, they are doing family trees to track back to a common ancestor. And what that means is that they're dealing with personal information for people who are completely unrelated to the charges. They just happen to be in some way remotely related to the defendant. So I don't believe they're going to get it. It'll be interesting because this is sort of a new and emerging area of the law, and different states are handling it slightly differently. Whew. Okay. The next case I want to talk about is Megan Imirowicz. A lot of you were following this case, and I wanted to talk a little bit about it. So Megan Imirowicz was 3 days past her 18th birthday when her father, who was a very severe alcoholic, was passed out on the couch. She was mad at him because he had promised to do something for her birthday and then passed out and couldn't do it. And so she was angry and threw a bunch of stuff on him. Now, the testimony is all over the place about what it was, where it came from, but apparently included in that stuff she threw on him was drain cleaner, lye, powder. And then it is uncertain how moisture was added to that. Her father was a very bad alcoholic. He was known to get so drunk that he urinated on himself. But moisture was applied to lye and water together create a caustic substance that can create very serious burns. And she was mad. She threw everything on him. She walked out of the house. Later, she was contacted and told that he had been rushed to the hospital because he was very badly burned. He was in the hospital for some period of time. He had other associated health problems, including the fact that he was a very serious long-term alcoholic. And after a month or two in the hospital, he died. She was charged with kind of an unusual statute of dispensing a caustic substance causing death. And she claimed that she did not realize what she was throwing on him, and that she didn't realize, and that she didn't throw any water or anything else on him. So the testimony was compelling, interesting. This really was a young woman who the rest of her family, her siblings, her mother was divorced from her father. Her siblings had sort of given up on him and said, I'm out of here. She really was the only one still left at home and trying to take care of this person who was severely disabled by alcohol. Having grown up with an alcoholic parent, I understand what that feels like, and how you can go on and go on and go on enabling this alcoholic parent and finally just have had enough. And she was very angry with him, and she threw all this stuff on him. So the jury found her guilty. And after some victim impact statements, the judge passed sentence. This was a fascinating sentencing. And if you get the opportunity to go onto Law and Crime, we'll post the link in the show notes. If you get the opportunity to go on Law and Crime and take a look at it, I have to say, having been an attorney who did a great deal of juvenile work and had a lot of young clients, I thought this judge's analysis was spot on. She analyzed the fact that this was a young woman who had had an extremely dysfunctional childhood. I mean, literally, this kid had practically been raised by wolves. And and that she had had serious mental health issues. She'd been hospitalized for mental health issues recently, and that the judge was very compassionate about the fact that this young woman really never had a chance to grow up and start a life. And the judge found that although she was guilty, that it would be unfair and inappropriate not to deviate from the accepted sentence. She sentenced her to a year in jail, but gave her credit for the 500 odd days that she'd already been in custody, and she was released. Now, I know that just like my opinion about Leslie Van Houten, reasonable minds can differ. And I know that there are a lot of folks out there who are going to say this was not a fair outcome. I thought that the judge's analysis about why young people whose brains are not fully developed yet should be treated differently was very compelling. She is a younger judge, woman, and I really felt like she had done her homework. And a lot of the arguments that she made in justifying this reduced sentence were arguments I myself have made over the years having to do with young offenders. One of the statistics about young offenders is that they are, because their brains aren't fully formed yet, their frontal lobes are not completely developed, they are also much more amenable to treatment, much more likely not to reoffend and to be rehabilitated. So the judge did enter quite a few conditions. At the request of the prosecution, she required that Megan be on an ankle monitor for the first 6 months, that she be on intensive probation to the probation department. That usually means that person meets with their probation officer at least weekly, sometimes twice a week. She also required her to immediately enroll in an education program, whether it was finishing a GED, whether it was college, whether it was re-enrolling in high school, any of those options. And I felt that that was an effective and intelligent way for the judge to deal with this particular crime. Every crime is different. Every defendant is different. And certainly I would not be making this argument for defendants like Ethan Crumbley or Aiden Fucci or some of the other young people who committed heinous crimes. Not to say that her crime wasn't heinous. However, there was certainly some question in the judge's mind about whether or not she understood the gravity of the action that she took when she threw that lie on her dad. And I think the judge struck a pretty good medium in doing that. So I know, I understand that we can all disagree about those things. And I have the utmost respect for people who disagree. And I love the fact that in our chat, we can express our opinions and we can have these conversations and we can disagree without being angry or nasty or unpleasant. And we can disagree without being disagreeable, as my grandma used to say. So I appreciate that I can express my opinion. Y'all come here to hear what I have to say, and that it's okay for us to have disagreements. I realize that I'm a defense attorney, and by nature, we're a little bit liberal. And a lot of people don't agree with that. And I understand it and respect it. And that is what makes our system, our democracy work, is that we're able to express our feelings and our opinions about things. Now, I wanted to talk about Michael Turney. This was an interesting case. This is a case out of Arizona where 31 years ago, no, 20 years ago, I think, um, a young woman disappeared. Her stepfather, who is an odd guy, really odd guy, picked her up after school on the last day of school, and she was never seen again. He claimed that she'd run away, that she called him from California, that she didn't want to be found. And he claimed that she was alive and well and living her life in California. Her younger sister, on the other hand, believed that Michael Turney had murdered Alyssa, was her name. So interestingly enough, this case came to the attention of a lot of people because the sister began a TikTok channel where she was talking at great length about her father and her sister. There were allegations that he was inappropriate with the sister. The background is a little bit more convoluted. Michael Turney was married to Alyssa's mother. Alyssa's mother died, and he adopted Alyssa, but she was not his biological child. Alyssa's mother and Michael Turney then had 2 other children, including the younger sister. So the case, he was prosecuted, and interestingly enough, a search warrant was served on his home, and it was discovered that he had pipe bombs and a whole bunch of other illegal explosives, and he was arrested, tried, and convicted for those charges and spent 10 years in prison during the time that Alyssa was missing. He wrote a manifesto. He claimed that the union had somehow had something to do with it, the labor unions. It was a very strange guy. So he was put on trial for the murder of Alyssa. Now, this is a case that has no body and no concrete evidence that Alyssa was actually dead. He was put on trial for that. And after the prosecution presented its case, as is the case in every criminal trial, the defense said to the judge, we want a verdict of acquittal. We want a finding of acquittal, a judgment of acquittal, because the state did not meet their burden. Even if you take everything they said in the light most favorable to the defense, they didn't meet their burden. And the judge agreed. This is an incredibly rare occurrence, very rare occurrence. But the interesting part about it is a judgment of acquittal means that double jeopardy attaches and he cannot be tried again for Alyssa's murder. Should evidence come up later that proves that he was responsible for her death and that she isn't in fact dead, that she is in fact dead. And the reason why this case is interesting is sort of pointed up by a development that happened today. Justin Lum announced today that a young woman who had disappeared in 2019, I'm going to look this up because I want to make sure I get the facts right for you. In 2019, Justin Lum had just posted on his Twitter feed that I got to look it up because it's just really fascinating. He had recently posted on his Twitter feed that it had been 4 years since a young girl whose name is Alicia Navarro went missing in 2019. And he was reminding people of the of the fact that she still had never been found. And he was recognizing that this was yet another unsolved disappearance of a young woman. She was 13 at the time that she disappeared. She was 14, sorry, at the time that she disappeared. And he announced this morning that she had been located alive and well and living in Montana. She was 14 when she disappeared. She was identified by her family as a high functioning person with autism. And lo and behold, she was discovered alive and well in a small Montana border town near the Canadian border. I think that's right. And alive and well. So the very fact that we had that happen on the heels of the court saying not enough evidence to convict Michael Turney, it sort of points out why it's important to have evidence, because there is no evidence that could be presented to the jury that in the Turney case that Alyssa was actually dead. And at least a tiny little suggestion that she was alive and well and living in California. So, well, I have managed to give everybody updates and talk lots and lots about all of these cases for an hour. And now it's time to take your questions. So let's find out what it is that you all would like to talk about tonight. We've had some really interesting legal developments with the I keep getting it wrong, YNW Melly case being declared a mistrial because of a hung jury. We've had Michael Turney, who was given a judgment of acquittal, and then of course we have Taylor Shabusiness. I say that. I'm not making fun of her name. She actually changed her name from some very mainstream name to Schabusiness. So anyway, and then all the way to Taylor Shabusiness, who's been found guilty after making very explicit confessions about her behavior following a night of spending a lot of time smoking meth. So let's see what kind of questions y'all have. Hi there. Lori's thoughts about the defendant and prosecution's arguments about Tammy's aunt. The defendant, the law doesn't allow it. The prosecution, no legal basis to contest, but legal interpretations can vary and ethics demands it. Interesting. Yeah, that's a good question. What the prosecution said was, we don't have a basis. There isn't case law to support permitting Tammy's aunt to testify, but there isn't case law that precludes it either. There isn't anything in the law. The law is silent. As the judge said, I think this is an issue of first impression, which means that there isn't appellate case law on it. And judges don't like opinions of first impression, impression cases, because they like the guidance of the appellate courts. But the prosecution sort of said, we're going to stand silent because we really can't take a position for a variety of reasons. One, the prosecution doesn't represent the victims. The prosecution represents the state, who has an interest in enforcing the law. So the defense basically said the law doesn't allow it, which I mean, maybe on a superficial reading of the statute, the law doesn't allow it because she's not a parent or child or spouse of a victim. But there is that provision in the statute that allows the judge to appoint a representative of the to speak for the murdered victim. And as the judge pointed out, there's nothing in the law, case law, or in the statute that says that the judge cannot appoint more than one person. So if the judge recognizes that Tammy's father and sister are victims as defined by the statute, he still can say, yes, but Vicky Hoban is an aunt, and I'm appointing her the same as I appointed Summer Shiflett and the same as I appointed Kay Woodcock to be the spokesperson for the murdered victim. So I think it's interesting. I think I'm certain that it will be added to the issues that'll go up on appeal. I don't think it goes anywhere really, because I think that the appellate court is going to say, no harm, no foul. I don't think if this had been a capital case where a jury was deciding mitigating factors and was hearing victim impact statements, it's possible that the appellate court could say, yes, having someone who isn't allowed under the statute to make a victim impact statement could sway the jury inappropriately. So, but I think because this is a judge making the determination, and judges are expected to be able to filter out irrelevant or inappropriate information, I think that I think it probably doesn't go anywhere on appeal. That's just my 2 cents. Ladybug Lady, how are you? I love that name, and it gives me this mental picture. Forever ago, I think I was in my first year of law school. I went down to Tucson, Arizona to visit my mother and father who were living down there. And it was really hot in Tucson. It was May. They were setting temperature records. And so we drove up to Mount Lemmon, which is the ski area, if you can believe that, outside of Tucson, Arizona. And a few days a year, it has enough snow to ski on it. And there is a beautiful ski lodge at the top of the mountain, and you can ride the chairlift all the way up to the top. So a friend and I hopped on the chairlift, and we rode the chair all the way up to the top of the mountain, had this beautiful view. But while we were standing up there, we realized that there was a ladybug hatch going on. And I have never in my life seen so many lovely red ladybugs. And we rode the chair back down to the bottom of the hill, literally gently brushing all the ladybugs off. So when I see Ladybug Lady's name, it makes me think about that. This is a great question. When there's a hung jury upon retrial, will the same jury sit for the case? Nope. They're going to have a whole new jury. I mean, it sort of makes sense if the presumption is that the jury that heard the evidence was unable to reach a verdict. Now, it's unlikely they're going to be able to reach a verdict if they rehear all that evidence again. So they will start out with a completely fresh jury. They will do the same thing they do in every jury instruction. There will be jury questionnaires. They will do voir dire of all of the jurors, and then they will choose a panel and alternates, and they will press forward. So it'll be a whole new panel. Good question, though. I want to acknowledge I have been watching these amazing super chats buzz by in the chat, and I just want to thank you all so very much. Those of you who know Michelle know how very much this means to her. She's probably going to kick me in the rear end for letting you all know, but she is having some health problems right now. So I appreciate beyond belief anything that you can do to help Michelle out. For those of you who might not know, every super chat, every donation through PayPal goes directly to Michelle. I don't see any of it. The little bit that comes in on YouTube ads goes to the show, and we buy new microphones and all those other things that happen. For those of you who might be interested, Michelle just popped out. She must have lost her internet. For those of you who are sort of interested and have watched as this wall filled up with quilt squares for our True Crime Quilt Guild, one of our followers very generously offered to quilt it. It is in her capable hands. And when it comes back, we're going to figure out a way to raffle it off. So it's going to end up in one of your homes at some point. So anybody who wants a flashy yellow and black quilt, look out for that. I also sent off my daughter's quilt finally to be quilted. I don't think she will ever believe it if it actually shows up for her, but hopefully we can get those projects done. I have an idea for a quilt project for Larry and Kay. And I'm still sort of noodling how we might be able to make that happen. But it would be a project where everyone would make a quilt square, and then we would assemble them and have them quilted for Larry and Kay. So if you are interested in that, it would be a pretty straightforward, pretty easy project to do. I would provide the pattern and then would do an instructional video to show you all how to do it. So I'm still following up a little bit, a couple of ideas, but I sort of have that in my head to do a little bit of a memorial quilt for them. So it looks like our sweet Michelle is trying really hard to get back into the chat and is having a hard time with it. So we'll wait to see if she can pop back in. And in the meantime, she's got some questions starred for me. So I'm going to pull those up while we wait to see if we get Michelle back. Hey, Thug Nasty. So are Chad's kids just sticking their head in the sand when they ought not to assert themselves as a victim to speak at Lori's sentencing regarding their mother's murder? This is a good question. I want to caution everybody. We don't know where their heads are at this point. We know that at one point, some months ago, there was a point at which they were still supporting Chad. I'm sure that they have been cautioned by Chad's legal counsel not to make statements prior to his trial because they may be more valuable to Chad in his trial than they are as victims speaking out about their mom. I expect that they are not they're not a 5-person hive mind, that they have different opinions and different feelings about what's happened. I expect that they probably have different feelings now that they have seen at least some of the information in Lori's trial. And so I don't know where their minds are. I think that Tammy's family is going to be adequately represented by her parents and aunt. And I wouldn't jump too quickly to the conclusion that that they're sticking their heads in the sand. But there are a lot of factors that go into making that kind of a statement. So we're going to give them grace because we don't know what it's like to walk around in their shoes. We're going to give them grace. We're going to give Adam Cox and Uncle Rex grace. And I know that that doesn't set well with a lot of people. People have opinions. We all have them. You know what they say about opinions? Everybody's got one. I won't finish that. But I come down on the side of grace because I don't know what it's like to walk around in Adam Cox's shoes. I don't know what it's like to walk around in Emma Daybell's shoes. I don't want to. I don't want to know that. I don't want to live with those images in my head that they have to live with. So it's okay with me if we let them work out their pain in their own ways. I know that there are other people who feel very differently. And y'all are welcome to go seek those people out online because they're angry and bitter. And I have enough of my own flaws not to judge other people too harshly about things that I can't speak to. So I'm going to give them all just a little bit of grace. I am going to pop out for 1 second and send Michelle a new invitation to our chat because she seems to be having trouble getting back in. So hang on just. I'm back. Thank you for your patience. Looks like Michelle's back too. So I'm going to cruise up and see if I can find another question while Michelle gets oriented. Hi, Jill. Any thoughts on the Carly girl that faked her own disappearance in Georgia? Can't remember her last name. Will they prosecute her? This is another really tough case. It's perplexing because we don't really know why this happened, but you gotta wonder if this girl, she's young, she's early 20s. You gotta wonder what sort of pressures would come down on her to the point where she would fake her own abduction. We don't know. We do know that she faked her own abduction, that she was missing for somewhere around 48 hours and that she showed up at home and with quite a story about having stopped because there was a toddler walking along the road, about having been abducted by a man with red hair and a woman. And I mean, she had a pretty elaborate story. But you gotta wonder what was going on in this young woman's life that she thought that the only alternative for her was to fake an abduction. This is certainly not the first time we've seen this kind of thing happen. We have seen very well-known, widely covered cases where young women have claimed sexual assault and then it's been proven that it didn't happen. So that is going to be up to the Georgia authorities to determine whether or not there are any sort of extenuating circumstances, or whether prosecution's appropriate. I know that they mounted a 48-hour search for this young woman, that they expended a lot of resources, but you got to wonder what motivates somebody to do something like this. This seems like it might be the perfect case for a prosecutor to step back and say, let's see whether this young person needs some serious mental health treatment, and whether or not we could agree that if she seeks the mental health treatment that she needs, that we won't prosecute. And oftentimes that looks a little bit like we're going to hold off on making a charging decision to see how she reacts and what she does to remedy the situation. It appears that she's repentant, although she's only making statements through her attorneys at this point, but she didn't, I think, did meet with law enforcement. So that was a step in the right direction. And it seems to me like maybe legal prosecution might not be the best way to deal with it, but we'll wait to see what the Georgia prosecutor does, because certainly it is a prosecutable case. She did make a false report to police. So, okay. Hi, Michelle. Nice to have you back. Thank you for posting. I'm glad we were able to figure out the technical difficulties. Fradis asks, if the accused decides to say something at sentencing on Monday, will she be the last person to talk after victim statements or before? You know, that's somewhat discretionary with the judge, but in general, they are allowed to speak last. I do not expect that we are going to hear from Lori Vallow. I don't. I believe that her attorneys are going to tell her it would be a mistake because there are lots of appellate issues and they wouldn't want to in any way jeopardize any of those appellate issues. And I don't believe that we are going to hear a slight modicum of regret on her part. Remember that the pre-sentence investigation will have happened, and the investigator who does that evaluation will have interviewed Lori and will be able to communicate to the judge if there is any sense that Lori is repentant, regretful, that there's any suggestion that she regrets or is repentant of her actions. Again, I think that sometimes what happens is that a defendant standing up and making a statement and saying, I'm so sorry for how my actions impacted you, can be a Fifth Amendment, a violation of their Fifth Amendment rights, a waiver of their Fifth Amendment right to remain silent. So far, she has been exercising that right, and I would not expect her to make a statement. So good question. But I would be very surprised if she makes a statement. Hi, I think this is Tennessee Girl, 79. Do you think Judge Boyce has already determined her sentence or will have before court begins on Monday? He knows what she did, and I doubt any statement will sway him one way or the other. I think Judge Boyce will have a very good idea of what he intends to do. I also think, and y'all know, I am not a fan of Judge Boyce. Y'all know that. But I'm going to give the man credit where it's due. I think that he will listen to the statements that are made, and he will take them to heart as he's making his decision. Now, I think that he has a pretty good idea of what he intends to do. The reason I say that is because he's got a pre-sentence report, and that pre-sentence report is going to be more thorough and more in-depth than anything he's going to hear in court. he's going to hear very emotional arguments from Kay and Larry, from potentially from Summer. He's going to hear very emotional responses from Tammy's family. But he's also going to have that more concrete information to consider from the pre-sentencing report. So I think that he will carefully consider what he hears in court, but I also think that he already has an idea of what he intends to do. He has done the research. He knows what is allowed under the law. He knows how to lay out his findings so that it will explain and to some extent justify the findings that or the sentence that he's going to pass. So I do believe that he has given a lot of thought to this before Monday, and I think that he'll be fair. I think that he will listen carefully to what the victim impact statements say, and he'll take that into consideration. I think that it will be. I don't think that he is going to hear anything except that those people want justice for the victims. So I don't think he's going to hear any pleas for mercy from any of those folks that would sway him one way or the other. Good question. Denicia Rose, I was very surprised to hear both the prosecution and defense read the victim impact statements. Is this standard procedure, and wouldn't the defense tell Lori about the letters? Lori has a right to see, she has a discovery right, so she has a right to see those letters. It isn't really going to change what's presented in court, so she has a right to see them, and her attorneys have a right to review them and to in some way perhaps prepare her for what she's going to hear. I don't think that it is surprising that the defense and the prosecution have read the victim impact statements. It's pretty much standard. They are provided to everyone, and everyone has the opportunity to read them. So it will be up to the person making the statement whether they want to read their statement or whether they want one of the prosecutors to read the statements. Some people are not comfortable speaking in public and want somebody else to read their statement. So that happens sometimes. But it doesn't surprise me that everyone's read the pre-sentence report and all of the statements that went into that and are prepared for what the victims are going to say. Question: how is the order of the people talking on Monday to be determined? Who talks first and last? This is primarily going to be up to the judge. So the judge is going to decide the order of who will make victim statements on the record, the public statements. Now, some of those victim statements have been compiled in the pre-sentence report, which we don't get, which is confidential. So some of those statements won't be made in open court, but those people, Kay, Vicky Holben, Tammy's father, and anybody else who's on the list of advocates for the victims, it will be completely up to the judge what order he takes those in. To be honest, I don't know that it's going to make a huge amount of difference who goes first and who goes last, because I anticipate that every one of those victim impact statements is going to be demanding that the judge throw the book at Lori and that she get the maximum sentence. I don't foresee that there is going to be anybody in court on Monday who's going to be pleading for mercy for Lori. When we for you. When way for you. Will her mental health records come into court and into play for mitigation purposes, and will her diagnosis be read in court? I don't believe that they will talk about her specific diagnosis in court. That is information that is contained in the pre-sentence evaluation. Everybody's got it, and the judge will be considering it, but I don't believe that it will come in. It is possible that the defense could put on an expert witness to talk about her mental health, about the impact of her extended incarceration might have on her mental health, and any other things that contribute to that the judge might consider in determining a sentence. But to be honest, it's all in the pre-sentence report. So I don't anticipate that the judge is going to delve deeply into her mental health issues. Remember that the pre-sentence report takes the place of the presentation that would be made if this were a death penalty case, the mitigation phase. So all of that information that would be presented to a jury in a mitigation phase is being presented to the judge in a pre-sentence report. These are all really good questions, and we don't often get to talk about pre-sentence reports and sentencing in these cases. We've been talking about procedural and court and trial stuff for a long time, but we haven't had the opportunity to really talk about sentencing until now. So these are great questions. Sarah Adams, this is an excellent case. Taylor Shabusiness. Could it be meth-induced psychosis? Now, I have been involved in cases that involved meth-induced psychosis. It is a real thing. It is people using methamphetamine, which impacts a part of the brain, acting as a stimulant, to the point where they have a break with reality and become psychotic. And it is possible. In order for the court to consider a meth-induced psychosis, though, we have to get beyond the rule that says that you don't get a pass if you are voluntarily intoxicated, or that voluntary intoxication does not constitute a mental disease or defect. Now, if she currently is psychotic as a result of meth-induced psychosis that persists, which would be unusual, then perhaps the defense could make the argument that she is not currently competent. But her competence to stand trial has been examined, and she was found competent to aid and assist. So remember, there are two different issues having to do with mental health. One is the defendant competent now as she sits in trial to aid and assist in her defense? And the other is, was she suffering from a mental disease or defect at the time she committed the crime that would preclude her understanding her actions and the wrongness of them? So I have seen cases where meth-induced psychosis came into play. One that comes to mind for me is a child welfare case where a mother was admitted to the hospital in labor and in a full-blown meth-induced psychosis, and where her children were removed from her because of her mental disease or defect, based on the fact that she was in a full-blown meth-induced psychosis. But that is a different circumstance from legal criminal responsibility, because criminal responsibility would say that you don't get a pass if you voluntarily engage in the abuse of a substance that causes this mental disease or defect. Hopefully that made sense. So it will be interesting because if there is proof that there is organic brain damage caused by her use of methamphetamine, that also could cause psychosis. It's a slightly different mechanism because what we think of as meth-induced psychosis is a person using so much meth and being so hyperstimulated that they lose touch with reality. And that's a condition that resolves once the person is no longer under the influence of meth, once the meth is out of their system. That's slightly different from a person who becomes psychotic because of the physical damage that's done to their brain cells as a result of extended use of methamphetamine. So they're slightly different, but it will be interesting to see what the defense does with that. If I were, if I had been the defense attorney, the first thing I would have done would have been to go get a neuropsych evaluation. So having a psychologist who can actually evaluate her actual brain functioning to find out whether or not she has brain damage from all her drug use. So excellent question, though. Kathy Crosby. Is Colby Ryan going to submit a statement? We don't know. He has not publicly asked to make a statement, but we don't know whether he contributed a statement to her pre-sentence report. I would suspect that he did. You saw him testify and you heard him on that gut-wrenching recording, jail recording with Lori. He is angry, he is hurt, and I'm certain that he wants a voice in the outcome in Lori's sentence. So I would be very surprised to learn that he had not submitted a statement for the pre-sentence report. I expect that he probably has. That said, he probably also is not in a place that he wants to come and publicly make a statement. So it would surprise me if he's there to make a statement. It would also surprise me if his wishes weren't considered in the pre-sentence report. Friday vote? Okay. Anybody want to vote? Maybe we should do a poll. Hi, Tennessee girl. Question regarding Sarah Boone. If her allegations are true, what impact could this have at trial or an appellate level should she be found guilty? I think what you're asking is whether or not they are going to use the battered woman defense. And the battered woman defense is interesting. It has been used with a wide spectrum of success or failure over the years since it was originally brought in the 80s. And it goes something like this. This is a person who is so abused and so victimized by the defendant, by the person they're accused of murdering. This is a person who has been so victimized by that person that they cannot, that they had no other choice but to, excuse me, and excuse me again. I didn't even have time to hit the cough button. It's not a sneeze button, I guess. The question is whether or not that person has been so victimized that they in their minds felt that the only recourse to save their own lives is to kill their abuser. This goes back to the burning bed. This goes back to a woman who who had been so abused for so long that her abuser came home one night drunk, passed out on the bed. She sewed him into the sheets and then set the bed on fire, which has always been one of my favorite comments is, men, you can't live with them and you can't set the bed on fire. However, the battered woman defense has been used, with varying measures of success over the years. I don't believe in this case she's going to be able to make that fly, because you really have to get to the point of being able to say, it's kind of like the voluntary intoxication rule. You really have to get to the point of being able to say, I was in such a mental state that in my mind, I knew there was no other alternative. I don't think that you get there if you look at the recordings of her taunting him while he zipped in the suitcase and him saying to her, Sarah, I can't breathe. Sarah, I can't breathe. It's chilling. And she's saying, well, you should have thought of that before you choked me. And sorry, got to rearrange the hip here. So I think that's going to be a tough sell. It'll be interesting to see whether or not they can make that stick. Part of it is going to turn on whether or not this couple have a long history of abuse, whether or not the victim, the guy in the suitcase in this case, had a long history of being an abuser. Sometimes that can be persuasive. If you can say, this guy has a long history. She's not the first woman he's ever abused. He's been abusing her for years, and she felt boxed into a corner. And when she saw him in the suitcase, the only thing she could think of was, I can't let him out. He'll hurt me. I can't let him out. This is my only recourse, to leave him in there. It's going to be very fact specific whether or not they can make that fly. Good questions as usual, folks. Hi, Jill Schneider. Any thoughts on the Carly girl? Okay. We answered this one. I think I pulled it up, Michelle, while you were trying to get back in. So we talked about Carly and we answered that one. Thanks. So are Chad's kids? Oh, we answered this one too. I caught up. Will you be on after the sentencing? I think so. I think that I will try and come on after the sentencing on Monday night, at least for a short time, because I'd love to hear what you all think about what happens and answer questions. So I think we will try and do a shorter live. We won't do 2 hours by any means, but I think we'll try and do a shorter version to just get a little feedback and talk about what happened. I think we are all looking forward to this milestone in the case. I think we're all looking forward to, I wouldn't call it closure, because we still have Chad coming up, and I don't think that the families will feel that sense of closure until Chad's trial comes up. But I do think that we are all looking forward to this milestone and to moving forward with resolving the case completely for the victims. Any more questions, everybody? We're a little over an hour and a half, so I'm just I'm available, since I feel like everybody got a little cheated last week when I wasn't here. So let us know if you have any other questions. I want to thank everybody for joining us. I again want to thank everybody for your concern for me. I had a lot of folks who reached out to me in DMs or on Twitter and wanted to know on Facebook in our group, wanted to know if I was okay, if my mom was okay. So I really appreciate it. It wasn't that I didn't want to share it with you. It just felt like it was a lot to explain why I wasn't going to be there on Wednesday. And I knew that we would have the opportunity to chat tonight, and I would be I would be able to explain. And so I just want to thank everybody for your sweet outreach for me. And I want to remind everybody, Sarah, I'm going to get to your question just a second. I want to remind everybody that if you have questions that I haven't answered, post them in the comments or drop me an email if you don't like posting them publicly, and I'm happy to answer them. I will admit I've been a little slow on my emails recently, but I appreciate them and I do try and answer everyone. Sarah says, any connection you see between the Long Island serial killer, LISK as they're calling him, and the Atlantic City murders? I don't know. I think officials are saying that the way the bodies were positioned suggests that it could be someone different. But we also know that serial killers sometimes change their methods. We know that as that their methods evolve as their crimes evolve. So I don't think it's outside the realm of possibility that that he could be responsible for those Atlantic City murders. We know that he traveled a bit. Atlantic City isn't a far cry from New York, and so I think it's reasonable for them to investigate and decide whether or not they're related. But I think law enforcement are looking at a variety of unsolved murders. They're looking at unsolved murders in the Las Vegas area where he had a timeshare. They're looking at unsolved murders in South Carolina because he had property there. I think they are looking across the board at unsolved murders. One of the reasons is because this person was relatively affluent, he had the ability to travel. And so we see that with serial killers. We see serial killers who are who have less resources. We see them sort of concentrating their activities in a certain area. But Israel Keys is an excellent example. He was able to travel, and it is true that when you have multiple jurisdictions, you have varying degrees of expertise in investigation, and you also have law enforcement who may not be able to connect those dots and say, this killing in Atlantic City bears a lot of resemblance to this one in South Carolina or wherever. So the fact that that this case has gotten a lot of publicity means that jurisdictions all over the country are looking at unsolved cases. And I think that's one of the advantages of cases being widely in the media. And maybe one of the advantages to our online community as well, because we have some super sleuths out there who are really interested in connecting dots. That's kind of what they do best. So I wouldn't be surprised if they were, if he was connected. On the other hand, the law enforcement wasn't quick to say, it's possible. They were quicker to say, well, maybe, but there are not enough similarities for us to really to really nail that down. I think we're going to see a lot of additional investigation coming into play in this case. I mean, remember, he's only been charged with 3 of potentially 11 murders that happened and bodies that were found in that general area, in the general area of Gilgo Beach. Not all of those murders had similar methods either. In many of those cases, those bodies were dismembered. And one of those cases was a mother and a child, one of those cases was a man who may have been transgender or may have been presenting as a woman. So I don't think we know enough yet, but I think officials are really digging. I mean, we saw them literally go in and dig up the backyard, take down a deck, uh, go into his house and dismantle a vault where he kept his guns. I mean, we have seen them really make a concerted effort to connect up evidence. They're into storage units, they're in his office, I mean, I think that we're seeing a really thorough investigation. So if there's opportunities for them to connect it up with other unsolved murders, I think they're going to do it. Remember, New York has tremendous resources. It's a big city, and they have a lot of law enforcement resources. So this is no small town Moscow, Idaho investigation. Not to say that the folks in Moscow didn't do a good job, because they did, but just pointing out that they have the manpower and the tech and the resources that another small town jurisdiction might not have. You know, guys, great questions tonight. I really appreciate all of you being here. I love our chats. I love the opportunity I get to visit with you. I am working every day on the Lori Vallow and Chad Daybell book. I am writing every day. I am researching every day. I am reading every day. And then trying to, on top of it, stay on top of some of these other cases so that we can have these really stimulating conversations. So those of you who subscribe to the newsletter have noticed that I've been pretty remiss in putting out newsletters. That is a variety of reasons. One, by the time I'm done writing all day, the last thing I want to do is write a newsletter. And two, there haven't been huge developments in the case that required deep dives into the legal issues in the Vallow case. I expect we're going to see some of those as Chad's case gets closer. And I also am going to do my best to get a newsletter out talking about sentencing. Because I think it's important for those who are interested in sort of the differences in sentencing and why Idaho might be different than, say, Arizona, where Lori also has charges. That might be sort of an interesting deep dive for next week. So thanks again for joining us tonight. Thanks for always being there. Thanks for paying attention and making sure I'm okay. Thanks so much for all of you who so generously supported Michelle tonight. I can't tell you how much I appreciate that. And I'll be with you on Monday, and we'll be back on Wednesday with another wrap up. I think by then we're going to be able to talk a lot about Taylor Shabusiness and whether or not she is guilty but insane, or not guilty by reason of insanity. And I keep correcting myself, because guilty but insane and not guilty by reason of insanity are two very different things. And that might be something we can talk about too. So stick with us. Join us on Monday. We'll get information out about when that's going to happen as soon as we know. And I'll see you back here on Wednesday. Good night, y'all.